Mr. Flanagan, on the State versus Troy A. Tomlin, that is here today on the motion to withdraw a guilty plea as well as a sentencing hearing.
Yes, sir. And I have met with him, and to do right by him, I want to spend some more time with him and go over everything that he has. And he's been cooperating with me. So I'm going to ask the court for additional time to discuss this case with him. And I want to look at all the evidence that he wants me to look at.
Whose case is this from the state's position? Mr. Brooks?
Fine, Your Honor.
You said several times, and that's my concern.
Well, I just got appointed
I know.
very recently, so I haven't had a chance to do what I think he deserves.
Well, given that the state's position that if his motion to withdraw his plea is granted, that this will just be set for trial and that there will be no offer, I'm fine with Mr. Flanagan having one more reset to make sure he can go over the.
You think you would be ready by the 12th or the 11th of March?
Yes.
It's just resetting for 11th of March to be heard. That's our criminal docket call day, and we'll just go ahead and set it for March the 11th. That'll be the last time I can reset it on his motion to withdraw his plea. And Mr. Brooks has stated that if he withdraws his plea, then, and I grant that, then it'll be set for trial without any offer of settlement. So, then we'll set it for March the 11th.
Yes, we'll be
Thank
ready.
you.
See you Sunday.
2022 CR 319, State versus Troy A. Tomlin, Mr. Flanagan's case. Put it on the second call here for the motion to withdraw a guilty plea or for sentencing hearing if the motion is denied. So.
I got my 3 arraignments. Already did those. Excuse me. Excuse me.
Rose, you need me to sign up? Senor Perez, I'm going to change the date from the 11th of May to the 11th of March. Daylight savings time only advances of 1 hour, not several months. So.
It's kept me in trouble all day today. I didn't change my clock.
I've had that kind of day. I've already spilled a cup of water on my desk up here already, first thing this morning. So.
Yeah.
Thank you, Judge.
If it don't change the month, just change your clock.
Mr. Tomlin's got a motion to withdraw his plea.
We're ready to proceed on that motion, Judge. He wants to withdraw his plea.
All right. We will. All right. We may be doing this after lunch. Have you got someplace else you go?
No, this is it.
Let's just take this up at 1:30. The reason being is I've got to also read an indictment to an individual to arraign them. So, Mr. Sensei, you have something else?
Well, to that point, Mr. Ricks informs me that he misunderstood. He no longer needs you to read that indictment to him. So, and then I just thought I'd, as friend of the court, let the court.
Well, it's going to take some time for this hearing on the motion to withdraw his plea. So for that reason, I think it would be better to start it at 1:30. Okay. We've got some other motions. We'll take this up first. We'll come back at 1:30. All right. State of Tennessee versus Troy A. Tomlin Jr. Motion to withdraw plea. Stay ready?
It is ready, Your Honor.
That's ready.
Yes, sir.
My reading of the case law is that the defendant who seeks to withdraw his guilty plea is required, he has the burden of proof and the burden to establish a fair and just cause. So that would seem to me to be Mr. Tomlin's burden, Mr. Flanagan.
I agree, Your Honor. Call Mr. Tomlin.
Mr. Tomlin, if you'll come around, please.
solemnly swear or affirm the testimony given in this case to be the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am.
Would you state your name and spell it for the court reporter, please?
My name is Troy A. Tomlin Jr. Troy spelled Troy. A. Tomlin, Tomlin Jr.
Okay, thank you. Now, before I start asking some, what I think might be confusing questions, let me ask you this. Was a mental competency evaluation done on you in this case?
Yes, sir.
And did they determine that you were competent?
Yes, sir.
Are you now receiving government benefits of any kind?
Yes, sir.
And what is that for?
For mental disability.
Okay, so you have been determined to have some mental disabilities?
Yes, sir.
Now, I've listened to you speak today. I've spoken to you before. I've looked at your signature. Do you have a hard time understanding things?
Yes, sir.
Okay. Now, do you remember entering a plea back, I think, in September in this court?
Yes, sir.
Tell Judge Wolfe, what was your understanding of what was going on?
My understanding was I told him I did not do it, and I didn't.
You said him. You told who?
Told Tyler Howard that I did not do it. He told me that I didn't have a choice but take the plea deal. And he said, Judge Wolfe is very mad at me. If I did not take it, he would hammer me if I did not take it. And I was confused a lot about everything. And I was scared that they was going to revoke my bond if I did not take it.
Okay, so the day that you were in court, it was your belief that your bond would be revoked if you did not take the plea?
Yes, sir.
And that you would go into custody?
Yes, sir.
All right. And did you maintain your innocence to your lawyer?
Yes, sir.
And do you maintain it today?
Yes, sir.
Okay. What is your understanding of the sentence that you could have received at a sentencing hearing?
Thought that I was in probation or something.
Did you know that there was a possibility that you might go to prison at the sentencing hearing?
Maybe.
Okay, if I told you, let me just tell you something and you tell me what it means to you. 2 to 4 at 100%. What does that mean to you?
I don't understand.
Okay. And you're asking the judge to let you withdraw your guilty plea
Yes, sir.
and proceed to trial.
Yes, sir.
That's all I had, Judge.
Post-examination?
Mr. Tomlin, in your words, what did your attorney Tyler Howard say to you about this plea deal?
He told me that I will get 2 to 4 years depending on what the judge gives me. And he told me that I will have to have counseling after I get out. And I gave him everything I had on evidence. He had everything I had.
I didn't ask you that. I asked you, what did he say to you?
Sorry. In the room.
What did he say to you about this plea?
He told me 2 to 4 years at 100%.
At 100%. What does 100% mean to you?
Tell you the truth, I'm not good with numbers. I don't really understand. One of my disabilities, I have comprehension issues. It's actually been through all my life. I have comprehension.
I didn't ask you that. You said you have a disability. Do you have any proof of that today aside from your testimony?
Yes, I gave it all to my lawyer.
Which lawyer?
Michael Flanagan.
All right, so this lawyer has the physical proof of your diagnosis.
Yes,
Okay.
because when y'all did a competency test on me, Centerstone sent me to Trust Point Hospital Mental Ward, and I was assessed. At that time, and Tyra Howard did not give it to the courts. I told Tyler Howard that I was in a mental ward before he gave the competency test to the judge.
Do you remember meeting with Dr. Moore for your evaluation for this case?
Yes,
How many times did you meet with Dr. Moore?
2.
Okay.
And I was confused with what she was saying sometimes, and she was talking about my kids, and it made me very emotional.
Okay. Isn't it true that you did not cooperate during the evaluation?
I cooperated all I can, every answers.
So would that surprise you? Would it surprise you that Dr. Moore in her report said Mr. Tomlin did not cooperate during the evaluation, and he presented severely limited, which was likely an exaggeration. Would you refute that?
Yes. I don't know what a few means, but
The first report says you're malingering, and you may not know what malingering means, but let me assist you. Malingering means you're an intentional production of false or grossly exaggerated. Isn't it true that the first time you met with Dr. Moore, you were trying to grossly exaggerate your condition?
No.
You wanted to play this as an excuse, didn't you?
no.
Well, would you be
Sir.
would you be surprised that a doctor, a medical professional, would say that you are competent?
I was answering the best questions I could, and I was getting confused with what she was talking about.
You said you were concerned with that your bond might be revoked.
Yes, sir.
Why would you have that concern?
Because of I was scared that everything was going to happen, and on top of that, Tyler Howard did say to me in that room while my wife was in there, and my wife can come up too if she needs to, or on Zoom. She was my witness on it. He said that they may revoke my bond. They didn't take it.
Your wife's not here today, is she?
No.
You had plenty of opportunity to prepare for this hearing, and one of your key witnesses is not present today.
Yes.
And you know this is your burden to prove to the court that your plea should be withdrawn.
Yes, sir. My wife's pregnant and is in the hospital. She gets seduced in a week. She's pregnant. That's the reason why she's not here today, sir. And she's in Virginia on medical reason. She has Crohn's disease.
And what is your wife's name?
Erin Nicole Grove Tomlin. She'll tell you the same thing I'm telling you. As we speak, I'm scared also.
How many times did you meet with Mr. Howard?
Not too many,
Well, it's not too many.
meaning 2 times,
2 times.
3.
3. All right. What did you do with Mr. Howard over those 3 meetings?
Talked about the case, and that's it. When I tried to get a hold of him, he did not answer.
Okay. So you had 3 meetings with Mr. Howard prior to this plea, correct?
Yes.
All right. And did y'all discuss the proof in the case?
He discussed the proof, some of it that I don't remember.
You don't remember. Did he discuss the offer?
Yes.
All right. And what did he say about the offer?
He said it's the best offer to 2 to 4 years at 100%.
Did he give a reason?
He didn't give 2 reasons. He didn't even give a reason at all, but he told me that, and I'm going to address to the court, that he told me in that room that even if I go to trial, I can beat the rape cases, as he said that there's no evidence stating that fact.
So what kind of proof did he go over with you?
He didn't show me no pictures. My
What pictures are you referring to?
He said that y'all had some naked pictures, but basically I was never shown nothing. I was never shown any evidence of that. He never showed me any evidence of a kit test done. He never showed me
A kit test?
Yes. He never showed
What are
me.
you referring to as a kit test? I don't know. Are you assuming there's a kit test?
But I looked up on YouTube, and what a person told me.
I'm not concerned. We can't talk about what people told you, other than your attorney. You're claiming ineffective assistance of counsel from your attorney, Tyler Howard.
Yes.
Okay. Did he go over your confession?
Yes, sir.
All right. And what did he have to say about your confession?
I don't remember it from that day. I know he gave me a flash drive and I rewatched it. Detective Ball, in that fashion, it's skippy and glitchy and the words don't match up. And he made me sign a waiver. Then after that waiver, he told me that some of the fashions, what I was told at the end, but he also told me that I told you, if you answer my questions, I'll take you home.
Okay.
And later on saying, don't make me pry it out of you. And I took it as a threat and I told him whatever he wanted to hear because I was scared.
So when did it dawn on you?
And
Okay. So when did it dawn on you that you were going to serve time?
last minute.
Last minute. What's last minute?
It takes me a while, a very long time to comprehend stuff.
Okay, well, but what does last minute mean?
I don't know what it means.
Does it mean 48 days? Does it mean 2 days? Do you mean did you walk out of that play and go, man, I made a mistake?
Me and my wife was talking about, yes. I
Okay.
made a mistake,
Was that right after the plea?
yes. And then I tried to get in touch with Tyler Howard, and they told me that he would have go and get in contact with me. And then I never heard back from him at all.
Is this your wife's decision or your decision?
I just
Okay.
I talk everything with my wife.
Did you talk about the plea with your wife beforehand?
She was in the room with us.
Okay, so she heard.
She knows everything.
Okay. And that was prior to the plea.
Yes.
Do you remember me talking during the plea?
I watched the video of YouTube. He was talking.
Okay. Do you remember when I inserted myself and made sure that it was on the record that one, you're going to be on the sex offender registry, correct?
Yes.
When you got released. And then two, I even mentioned 100%, didn't I? All right. And I also mentioned that it was to serve, didn't I? That only thing that we would be determining here today at sentencing was whether it be 2, 3, or 4 years. Do you remember that?
Yes. I rewatched the video before I come in here.
Okay. And do you remember saying that day that you understood?
Me watching a video, I can say yes.
Okay. Do you remember that day saying you were satisfied with your representation from Mr. Howard?
On the video, yes.
Do you remember the judge going through a long explanation of your rights and what you were waiving when you entered that plea?
Yes. I had to rewatch the video multiple times to try to understand. And
So what is your valid reason to entering this plea and then waiting 48 days to file this motion to withdraw this plea?
Nobody told me the exact time or date to revoke the plea. I asked Tyler Howard multiple times. I even called his office, and the staff told me that he will call me back, and I never got a hold of him until that last minute. I called him multiple times, and I have phone records if you want to look them up.
It's your burden. Do you have your phone records here today?
No, sir.
Okay. That's all of this witness, Your Honor.
Redirect.
Judge, before I do that, I'm going to, for the record, the motion was filed by Mr. Howard as his attorney to withdraw the plea. Any references to ineffective assistance of counsel that's been put forth before the court today, I am striking. I do not want the court to rule on whether or not he received the effective assistance of counsel, because he would be forever barred from ever raising it again. So all we're relying on today.
We raised it though.
Well, you haven't ruled on it yet.
I believe his Aunt Arian Grove Tomlin, is that your wife?
Yes.
Disability doesn't actually show the reason why, but the records that I've seen do show that there was a proof that the Social Security Administration has given him a disability.
So anyway, I have no further questions, and I'll argue when the court's ready for me to argue.
Alan, you've discussed this with Mr. Flanagan. You understand that part of this case, that part of the agreement that was entered into back on September the 18th, I guess it was the dismissal of one of the charges, which is a Class B felony. You understood that to be part of the agreement?
Yes.
You understand that that deal may be off and it could be reinstated?
Yes, sir.
And that, do you understand if you were to go to trial, that the law, and I'm sure Mr. Flanagan's told you this, that the law provides that your conviction for sexual offenses could be run consecutively, meaning that you could get a sentence on each one of those 4 counts?
Yes, sir.
And you understand all of that?
Yes, sir. We went over it multiple times, and I feel
Speak
like
up now. What?
I've been speaking with him multiple times, and I feel like I'm starting to understand more with Michael Flanagan. Me and him's been working constantly to help me understand a little bit.
All right, step down.
Judge, can I ask him, based on what you just asked him? Mr. Tomlin, and just to reiterate what the court said, and I told you this, that the worst that can happen to you if you go on to the sentencing hearing is 4 years at 100%. I told you that, right?
Yes, sir.
Answer out loud.
Yes, sir.
Okay. And that if your plea is withdrawn and you go to trial and you're convicted of everything in the indictment, you're going to be subjected to much, much, much more than 4 years at 100%.
Yes, sir.
And you still want to withdraw your plea.
Since the beginning of this case, when this case was first, conceived, when this incident first came about, what are some of the things your daughter has gone through that you've seen?
The weekend after the alleged incident, she became suicidal. I caught her in her room cutting herself. She was desperately crying. She was afraid. And it got to the point over the course of that day, it was the Saturday after, that she was begging me to help her because she was going to kill herself. She had the plan, she had the ideations. I then took her to Rolling Hills Hospital, where they admitted her because she was a danger to herself. And she stayed there about a week and a half.
And what kind of treatment has she received since then?
After that, they immediately got her into a program in Dixon where she had outpatient therapy. She went several times, she was started on medication in the hospital, which she continued, but she started having a lot of adverse side effects. So she wanted to continue therapy. She did. She gave it a try. She didn't really connect with the therapist, so I've found her another therapist. She's been working on and off intermittently since then. She starts to feel better and feels like she can handle things, but then usually within a month or two, she's having nightmares again. She shakes a lot. She's says that she's scared that Mr. Tomlin is going to come and hurt her, and she's anxious pretty much all the time. Right now, she's recently asked me if she could see a psychiatrist. She wants really more in-depth help, and right now I'm working on finding that.
Was there any progress made when, well, let's start at the beginning. When this first case was conceived, did she love coming to the office and meeting with me?
No.
Was it difficult to get her to the office?
Yes. She didn't want to talk about it. She doesn't want to hear about it. She doesn't want to think about it. Of course, it keeps coming up over and over, and she has to, but no, I had to pretty much force her to come speak with you because she was terrified.
Has she been to a court date?
No.
Have you come to some court dates?
All of them, even one where was scheduled and I didn't know I didn't have to be here because it was rescheduled. I've been here.
September, when you heard the news that he took this plea, how did that affect your daughter?
She was shocked and extremely relieved. And she felt like he was going to admit his part in things, and she was glad that it was going to be over and she could move on with her life.
And did that change at all a month and a half later when you found out that he was trying to start this process all over again?
Yes. Yes.
How did that affect her?
Nightmares started to increase, a lot of anxiety. The therapist was working with her regarding that, and she was journaling a lot, but of course, she just wanted it to be over. Thank you. She just wants it to be over. So yeah, she was extremely upset, tremendous nightmares and fear. She started shutting herself in and not really wanting to go anywhere because she doesn't trust anyone. And she has voiced many times that she feels like he's playing the victim and she feels neglected.
Now, you and your daughter have been in my office before, correct?
Yes.
Okay, and we've discussed the potential outcomes of this case. And the outcome that was ended up being landed on, the 2 to 4 year sentence, that was something that y'all were on board with at the time?
Yes.
That's all I have as witness, Your Honor.
Ma'am, did you and your daughter talk about this incident at all?
Yes.
What did she say about it?
She says that she was on an app to help her meet people her age and her interest, and that's where she met him. And that she started telling me that he had a daughter named Katie who was also 14, and she wanted to be friends with Katie. And at one time she came to me and begged me to help Katie, saying that Katie had no food. That Mr. Tomlin was, he had 2 little girls, like, I don't know what age they were, maybe 2 and 1. And he didn't have any food for them or Katie, and asked her dad, who's my ex, to buy her some food. Then she asked me if I would please deliver that food. My boyfriend and I delivered that food, and that's when we met him, and he told us all about Katie. And she didn't really mention him after that. She just talked about Katie. The incident itself, are you asking?
Yeah. What did she tell you about the incident?
She talked about it.
When did she tell you about it?
The day after.
The day after the incident?
Mm-hmm.
Okay.
She asked me, she was 14 and she wanted a job, and she told me that Katie told her to come apply at Goodwings. So I took her up there. I watched her apply. I helped her fill out the application. I watched her interview in the parking lot. And I saw a text that evening from the manager stating that, they would try to work something out. And then she told me that Katie told her that, that she could go up there and watch, because Katie's dad actually worked there, and that she could watch and see if she would even be interested or able to do what it is they wanted her to do.
Okay.
So I agreed to that.
Okay.
That's the day the incident happened.
Okay. What did she tell you about the incident? What did she say the incident was?
She didn't, when I picked her up, she was very upset. She didn't really open up. I kept asking her what was wrong with her. And she said, I don't want to go back there. I don't want to go back there. But then the next day, she had calmed down about it. And I was like, well, do you want to work there, or what do you want to do? And she said, no, I don't want to work there. I can't cook. I agreed. I didn't want her near a fryer. So I agreed to that. And then later that day, she asked if she could hang out with some friends in Dixon, where the skate park is and the skateboard shop is. I took her there. I met some of the friends. She told me that Katie might come by, and I said, today I'm meeting Katie. I want to see Katie. I want to see this Katie. That never happened. When I showed up to pick her up, I witnessed her and Mr. Tomlin go into the woods behind Good Wings, across a little bridge, and go into the apartment complex behind. And then I drove around and I yelled her name, and they ran into the woods, and I called the police.
Okay.
That night, she told me everything.
Okay. What did she tell you? What was everything?
She told me that while she was hanging out at Good Wings that Thursday, that she hung out there and watched what they were doing. And at lunchtime, she and Mr. Tomlin went into the woods behind Good Wings, and they started making out, and that he laid on top of her, and they started having sex. And she told him she wanted him to stop, and pushed him, and he didn't stop. I said, well, why would you go back the next day? And she said, because he loves me. He told me he loves me, and that's just what people that love each other do.
Where did she go back to the next day?
That's when I took her to the skate area in Dixon.
Okay.
And she said she was going to see Katie.
Okay.
It was really him.
Okay. And so when she told you that, what did you do?
When she told me what happened?
Yeah. You called the police immediately?
Well, I had already called the police, and they were there, and I saw them talking to him after we left. And I told her I was going to have to do something about this. She begged me not to, because she felt guilty and felt like it was all her fault. And she started all the suicide stuff and cutting herself. And I did not call the police because I was concerned about her safety and getting her stable first. The policeman called a couple days later and told me that they did pick him up. And I can't remember if they called me or I called them, but they told me that they picked him up and questioned him, and that they needed to talk to a JB, and we arranged all that.
But did you take her to the hospital after this happened?
Assign a case manager who would contact the police, make a report. My main concern was her mental health.
I understand.
And that they were going to handle that part. I said, okay. They said they will probably contact you. And they even told me I could call DCS and include them, but that they recommended not to. They're going to go ahead and call the police, and they will basically take it from there, because she and I both were very distraught.
All right. Thank you. I appreciate it.
Thank you.
Redirect.
I just want to follow up. I neglected to ask this. How old was your daughter when this all began?
14. She had just turned 14.
How old is she now?
16.
Thank you.
Is she capable of testifying at a trial if that came to be?
I think that she is. I don't think she thinks that she is, but I do. She's terrified. But I've just about gotten her to the point that if she needed to, she would, because she's so tired of this ongoing process.
Understand. Anything else?
Nothing, Your Honor.
Thank you. Thank you, ma'am. You may step down.
Thank you.
Mr. Brooks, you may go ahead next witness.
That is the state's proof, Your Honor.
That just rested their proof. Any rebuttal proof, Mr. Flanagan?
No, Your Honor.
I'll hear you in argument.
Well, as the court knows, there's two standards. We're on the, I guess it's called the any fair and just reason standard because it's prior to sentencing. I'm not sure what that means, but I think the proof before the court is that the defendant didn't understand what was going on, and particularly because he talked about probation and the hope for probation. There never was going to be any probation. It was just going to be 2, 3, or 4 at 100%. His testimony about what his lawyer told him has been unrebutted here today. And I think under the law, it would be fair and just, especially in light of the prior witness's testimony, to allow him to withdraw his plea.
Your Honor, I think Your Honor has this case. However, I'm going to take an approach. So the case I'll be directly quoting from is State v. Phillips, 329 Southwestern, 3rd edition, 436,
Hand
2010.
that back. Brooks, I have the case in front of me.
I figured you did. Just want to make sure. All right. To withdraw a plea before sentence is imposed, the court may grant a motion to withdraw a guilty plea for any fair and just reason. Turn the page. Under this rule, criminal defendant who has pled guilty does have a unilateral right to later withdraw his plea either before or after sentencing. The trial judge should always exercise discretion with caution in refusing to set aside a plea of guilty to the end that one accused of a crime may have a fair and impartial trial. It goes on to cite the court's judicial discretion and that the defendant bears the burden of establishing sufficient grounds for withdrawing his plea. With respect to a more stringent standard, that's post-sentencing. Going further into prior to sentencing, factors that the court states that the court can look at, the amount of time that elapsed between the plea and the motion to withdraw it. 48 days in this case had passed before the motion was filed. The state would submit to the court that is an awfully long time for a change of heart. The court has illustrated that a quick change of heart is very understandable in these type of scenarios. However, in this case, we don't have a quick change of heart. We have a very delayed one, over a month and a half worth. Uses and abuses his alleged mental deficiencies to push things off, to bend the rules, to try to avoid prosecution. The state would point to both forensic evaluations conducted by Dr. Moore that should be in the court's file. The first one described him as malingering. That's very troubling to the state. That means he's not giving Dr. Moore a legit, basis to evaluate him on. And the second one, it shows that he's not cooperating. But even then, Dr. Moore, further states that he is competent to stand trial to assist his attorney in these proceedings. The state would ask the court to consider the trauma that this victim has gone in and out of throughout the entirety of these proceedings, and this defendant being allowed to enter a plea, withdraw the plea. Oh, I changed my mind. It's just throwing this victim through several mental hoops that will prejudice the state at trial, because the state could have had a clean progress. A lot of prep takes to prep these victims for trial. Me being a middle-aged male, it takes me a lot more prep to prep these cases for trial, especially dealing with young women who are alleged victims of sexual assault. I usually have to have several meetings just to get these victims to talk to me. So the abuse that this defendant, the abuse that he is trying to attempt to commit against this process will prejudice the state, because we go from
having a resolution to not have a resolution. It's not as simple as withdrawing a theft plea. It's not as simple as withdrawing an ag assault plea. There's a lot more mental hoops that these victims have to go through to make it to that stand. And the state would ask the court to consider that.
Anything else?
Just about the time frame, Judge, the uncontroverted testimony of Mr. Tomlin is, he was telling his lawyer he wanted to withdraw, and in fact, his lawyer is the one who filed the motion to withdraw. So that 58 days may not mean anything. He may have told him 2 weeks later, and it sounds like he was trying to get a hold of him long before it was filed. But other than that, just let the court roll.
Well, I'm going to take a recess and review this file, and I'll come back and give you my ruling.
All rise.
Brooks correctly cited, I think, the leading case, as far as I can determine, on this particular issue. There are plenty of cases allowing whether or not a defendant who has entered a plea and gone through sentencing and doesn't like the sentence they received, wants to withdraw their guilty plea. There are plenty of those kinds of cases out there. More recently, however, the appellate courts have started looking at some of those cases like today, where a person has entered a plea, but before sentencing, to determine that what is the appropriate standard and so forth. Mr. Flanagan correctly says he's not sure exactly what the fair and just is defined as being. And that's a factual issue that, unfortunately, this court has to wrestle with as well. The case that I'm referring to and that I'm relying upon in reaching my decision, State versus Phelps, which is a Supreme Court of Tennessee decision rendered in December of 2010, cited at 329 Southwest 3rd, 436. In that, they basically start by talking about, well, in that particular case, the defendant was charged with violation of the Registration Act, Sexual Offender Registration Act. He tendered an open guilty plea, but he moved to withdraw his plea prior to being sentenced. The trial court basically rejected that and said that the defendant basically had a change of heart, and because of that was an insufficient reason for him to be allowed to withdraw his guilty plea. So, of factors, and that was in the State versus Maxwell, and I think actually it was Spencer, State versus Spencer. United States versus Spencer was a federal case that they were adopting. The Court of Criminal Appeals established a fair and just reason for withdrawing a plea prior to sentencing, and set forth, and the Supreme Court adopted this. So those factors that the court has to consider are the following: the length of time between the entry of the guilty plea and the filing of the motion to withdraw it. In the case in Phelps, there was 7 weeks that had elapsed, and the court found that that was a significant length of time, almost 7 weeks, and that was a significant length of time. It's a very similar period of time to what we're dealing with in this case. Second thing is, why would the grounds of withdrawal not presented to the court at an earlier point of the proceedings? There's really no proof before me about why there was a withdrawal not, presented to the court. As I stated in the record, it was the first I saw of anything was a statement from his wife, who filed something on his behalf in November after he had pled in September. And at that point, I think then his public defender, Mr. Howard, filed a motion to withdraw the guilty plea after that. And that was also in November. So there's no real explanation for why it took that long for that to take place. The third factor was whether the defendant has asserted and maintained his innocence, and that has been the case with the defendant in this case, Mr. Tomlin. The circumstances underlying the entry of the guilty plea, the nature and background of the defendant, and whether the defendant has admitted guilt. The court hasn't heard any of the evidence in the case to know other than the plea that was entered at that time. And I will say this, I take note of what Mr. Tomlin said, that his lawyer said to him about me being upset with him going to hammer him or whatever. I don't know exactly what was said. That stems from on September the 18th when Mr. Tomlin came into court for status in the last plea day, I think it was. I noticed that he was wearing a Marvel Comics Superman costume underneath a t-shirt. And it was very obvious that he was wearing that. And I lectured him pretty fairly significantly about dressing appropriately to come to court when he was facing such serious charges that he could be appearing before a judge who could sentence him to prison time, that he needed to think more about what he was dressing. So I'm assuming that's the part that says they think I was mad at him. I wasn't mad at him. I was trying to advise him that he should or should not dress in an appropriate way. I will say that I was somewhat taken aback when I saw the nature of the charges, and when I asked him why he had the costume on, he told me he was going to go to Comic-Con. Comic-Con, to this court's knowledge, is one of those gatherings where there are a multitude of young people, including young girls who attend Comic-Con. And the defendant here was charged with aggravated statutory rape by force, sexual, and 2 counts of sexual exploitation of a minor. And I found at that point in time that he had no business going to Comic-Con with those charges pending against him, and I put that as a condition of his bond. So when he came in, I think it was a week later that he came before the court on our VOP day and entered his plea. And when he came into court, obviously that would have been something that maybe he was weighing on his mind. The most concerning thing about this particular case for me is the defendant's mental status at the time of the entry of the plea, because there was sufficient grounds that existed for this court to have ordered an evaluation, a psychological evaluation of the defendant. There was enough of a question that caused this court to order a psychological evaluation. When the psychological evaluation came back, Dr. Moore found that he was competent to stand trial and competent, and that he could not support an insanity defense. But as Mr. Brooks pointed out, Dr. Moore also opined that the defendant was malingering and perhaps presenting himself in a much more significantly impaired manner than he was. Beyond that, he's now been classified as disabled by the Social Security change of heart. We also caution trial courts, however, that a defendant should not be allowed to pervert this process into a tactical tool for any purpose of delay or other improper purpose. In that Phelps case, the court found that there was no real indication that the defendant was in any way disadvantaged mentally or whatever. I think he had a GED, and that he was capable of understanding the proper plea soliloquy, and that he had some prior experience, but he was a young person at the time when he entered some of his prior pleas. So they found that the factors weighed in favor of the defendant, and that was just because he had a limited period of education. In sum, the Supreme Court said that the record supported at least some of the factors that would establish a fair and just reason for allowing the withdrawal of the guilty plea. They examined the fact that although no proof was proffered on this factor, the prosecutor's statements that the plea colloquy indicate that the state was relying on statements the defendant made to investigating officers. This proof remains available to the state, and we conclude this factor is neutral. They went on to state that their review of the relevant factors convinces them that the defendant established a fair and just reason for withdrawing his guilty plea, and they did not find that the state's prosecution was prejudiced, and therefore they reversed the trial court and the Court of Criminal Appeals and granted the motion to withdraw the guilty plea and remanded it for a further hearing. So what I have before me is a set of factors that's somewhat even more difficult because of the simple fact that Mr. Tomlin has insisted his innocence and has portrayed himself as having a diminished capability, and he has someone who is identified as established by the Social Security Administration as the payee for his benefits. He has disability rating based on his mental disabilities. He was evaluated by court order because we were trying to eliminate the question of any sort of defense or competency issues. And the court is of the opinion that based upon all of these things, should I fail to grant this motion, the Supreme Court would likely, or the appellate court would likely find that that was an abuse of discretion. The thing I don't want to do is to put these parties and the victim in the case through having to sit through a sentencing hearing and make any sort of statements and then go up on appeal and be reversed and sent back for a retrial. I would rather grant this motion, withdraw the guilty plea, reinstate all 4 of those charges against the defendant, set it for an early trial date as quickly as we can get it ready, and let it go to trial, and he will face whatever the jury finds to be the appropriate punishment as far as whether he's convicted of those or not, and then he'll go to sentencing if he's convicted of anything. My understanding is, so based on all of that, and trying to wrap up what I'm trying to say, this is not an easy decision, but it's one that I think that I must make in favor of allowing a withdrawal of the guilty plea based on all of the factors that the court has considered, and that Phelps case, the Supreme Court's guidance indicates to me that that is what I must do. So I am allowing him to withdraw his guilty plea, reinstating all 4 counts of the indictment against him, and we will now talk about how quickly we can set this case for trial. I assume that we won't need to worry about the new process because there will be no plea offer made.
Judge, I do think there's going to be some motions to be filed, so we'll need a motion day.
All right. What about August the 7th for the trial?
I have nothing scheduled that far out, Judge, so whatever.
That day would be fine, Judge.
Any reason you can't try it on that day?
It looks like we will be in a felony murder case that goes, that is with Chelsea Smith and Emily Baker. Starts August 5th. Which DA's got that would be like
That's General Stribling and General Crouch.
Mr. Brooks does not have anything on that day, so Mr. Flanagan's available on August the 7th, so the trial will be State versus Tomlin. Mr. Brooks, I'd like for you to draw an order which represents or reflects my ruling on this. And the only reason that I have done this is because, as much as it pains me to do it, I believe that the young lady, according to her mother, is able to testify. I can tell you that had she been unable to testify at the trial, that would have been in favor against setting aside this. But in any event, Mr. Tomlin's been advised that their sentences on each of these carry 100% and that they can be run consecutively. He could be facing a much greater sentence. He still insists he wants to withdraw his plea, so we will allow that to happen. Go to trial on August the 7th.
Judge, I'll draw that order.
What?
Thanks, Judge.
Judge, the only matter I have left is Troy Tomlin. Mr. Tomlin, come up, please. Judge, I had filed a motion to dismiss, and I let General Brooks know I'm striking that. We just need a trial date. And a firm date if possible, rather than a backup to.
I agree with that. Do we have any dates in September? Is that too soon?
September won't. I've got too much in September.
I have State versus Robert Capes set here on the 3rd and 4th of October. Who has that case? We need, this case needs to be first on the docket. It needs to be tried. It's been continued. We've gone round and round with it, and so we need to try this case. We could set it on the 3rd and 4th of October and put the Capes as second behind this one. But do you need the Capes case tried?
And Judge, if we could make this number one on December 13th, ahead of Gamble and Smith, if you want to do that, as long as this is the first setting. Those people are on bond.
Well, Mr. Brooks, this is your case,
I'll
right?
move other things around to make sure I can.
Because this case is older, I'm going to set this case on the 3rd and 4th. Capes will be set behind it. And then you and Mr. Potter can see what you can do about it. All right.
Yes, you can talk to me. I'll be out there. I think that's all I have, Judge. Thank you.
All right. Give me a second to put this on my calendar.
All rise. Court is now back in session.
All right. All right, we have one case that's set for trial today, State versus Troy Tomlin. I do not see Mr. Tomlin at the table. Mr.
That is correct, Your Honor. As I indicated in chambers earlier, there's been some apparent mental distress issues with the client.
Well, without going further into it on the record.
That's right. I don't want to go further into it at this point, other than to say that he is not.
Oh, yes. December the 4th.
Well, I've got a seminar scheduled for that day.
Let me guess, it's your last chance to try to get your CLE that you're required to
Well,
before the end of the year.
Judge, I learned when I was in court in Davidson County from the Honorable Cheryl Blackburn, who questioned why I was still taking CLE courses because of my advanced age. I don't have to.
Is that true?
Yes, that's exactly what I said when she told me that. So.
Well, considering
We'll
you
see.
and I are the same age, Mr. Flanagan, that's news to me.
Well, it was news to me. So I will try to get a refund. I'll be here on December 4th, not be in the seminar.
All right, December the 4th.
Yes.
Well, there's nothing much I can do beyond that, since this was the case that was set for trial today and tomorrow. I have a jury waiting downstairs. I'm gonna have to go explain to them why they've been called in and not gonna get to do anything. So we stand adjourned.